My name is Jonathan Boisseau. I'm conducting my doctoral research on the doctrine of foreign state immunity under the joint supervision of Professor Andrea Björklund and at McGill and Professor Mathias Odi at Université Paris 1 Panthéon-Sorbonne. And the central thesis that I want to present today is that Professor Harold Coe's theory of transnational legal process provides a more robust framework for shaping the various rules and strategies that determine the outcome of state immunity disputes as compared to other legal theories. And I say that so because the theory embraces legal pluralism inherent to the state immunity doctrine, and also has both explanatory and predictive capacities regarding the development of the doctrine. So just as a general point and a reminder, the state immunity doctrine shields foreign states from civil lawsuit initiated by private parties in the national courts of other states, bearing some specific exceptions, mostly related to commercial activities of the state. And this doctrine operates both under customary international law and the national law of nearly all jurisdictions. So my thesis focus on the rules of civil procedure that give effect to this immunity of foreign states, addressing issues such as service of process, default judgment, and the prohibition of procedural sanctions against states. So as an introduction, the theory of transnational legal process developed by Professor Coe in the 1990s builds upon the term transnational law that was coined by Philip Jessup a few decades earlier. And Professor Coe's theory has four distinctive features. First, it is non-traditional, dismantling the long-standing dichotomies between the domestic and the international, and the public and the private. And it is also non-statist, encompassing state and non-state actors alike. It is dynamic, viewing transnational law as it constantly transforms. And fourth, it is normative, showing that transnational actors shape the law, and scholars must understand this process to better shape or reshape the law themselves. So my presentation has three parts. In the first part, I'll look into the theories that private international law and public international law scholars use to understand and critique state immunity rules. In the second part, I'll unpack this bold statement regarding the better applicability and usefulness of the transnational legal process theory to the state immunity doctrine. And the third part, I'll give an example to show why this theory is better than other ones to assess and critique state immunity rules. So starting with the first part, the literature on state immunity rarely explicitly present the theories of law used to understand and reform state immunity rules. But I argue that scholars from public international law, private international law, and transnational law typically rely on one of the three pillars of jurisprudence. So positivism, natural law, and legal realism. And they typically view state immunity as a balancing act between the sovereign prerogatives of the foreign state claiming immunity on the one hand, and the right of access to a court of the private party seeking to obtain redress on the other hand. So just to take a few examples, public international law scholars, for instance, as eminent ones like Gerald Fitzmaurice in 1933, claim that all endeavors to hold sovereign states accountable for its actions of any nature is inconsistent with its sovereignty. He believed that a foreign state does not cease to be a sovereign merely by engaging in action that might otherwise be performed by private citizens. On the other hand, Professor Hirsch Lauterpacht's 1951 naturalist argument highlighted the importance of curtailing state immunity. But he maintained that this is justified not simply by the expansion of the activities of the state and the unfairness of its competition in the commercial field, but by the principle of the subjection of the sovereign state to the rule of law. In private international law, to give an example, German scholar Ludwig von Baer wrote in 1892 that those who confidently asserted the absolute immunity of states without exceptions which he believed endowed foreign states with the mysterious splendor of inaccessibility, were wrong. He argued that when foreign states act on the territory of the forum state, much like private persons would, their sovereignty is either not engaged or implicitly waived using private international law doctrines. Moving on to the second part, as I introduced, my argument is that Professor Coe's transnational legal process theory and its 4 distinctive features provide a better framework for reforming the rules that shape state immunity disputes. And this is so for 2 reasons, I submit. And the first is that the transnational legal process theory embraces legal pluralism, capturing the diversity of state immunity rules, both across and within jurisdictions. And I'll give examples of that. And I'll start by the functionally equivalent, basically similar state immunity rules in different jurisdictions. So the theory shows that these rules, these state immunity rules, derive partly from each jurisdiction's legal tradition and its own laws, and partly from international law and comparative law. So, for instance, the decision of national courts on state immunity rules influence each other because courts cite other foreign decisions on state immunity issues quite consistently, especially at the higher levels of courts. And this is especially true on issues that are seen to be left unregulated by customary international law, like the issue of the piercing of the sovereign veil. But also international courts cite domestic court decision on state immunity rules to establish what those rules are. So as the ICJ did in holding that, in rejecting the argument that state immunity is no longer required in cases of serious violation of international law. And the transnational legal process theory and its pluralism embraces also the various rules that operate within a single jurisdiction and within a single dispute, because these diverse rules operate at different level of normativity, including the national, the contractual, the transnational, and the international. And again, I'll give example. So different commercial and business agreements that are signed between a foreign state and a private party can shape state immunity disputes. And a good example of that is the waiver of state immunity. The private party and the foreign state will sign in their commercial agreement a waiver of state immunity under the law of the contract. At the same time, this waiver will be subject to the rules on waiver of the forum state, which means the state where the proceedings are brought. That being said, while the pluralism that the TLP theory embraces showcase the coexistence of private international law, public international, and transnational law, it offers little insight into the subsequent step of analysis. What should we do with this? How do we resolve those conflicts? It's for reasons similar as those that Marty Koskianiemi claimed that pluralism, and I quote, is descriptively powerful, but cannot sustain a project of law in its own rights. And this is where I claim, and this is my second point, why the TLP, transnational legal process theory, is better, having explanatory and predictive capacities. So contrary to public international law and private international law approaches and their theories that often perceive law as a formal body of rules to be analyzed as a substance, Professor Coe's theory posits that law is a process of authoritative decision-making. So as he shows, engagement in the transnational legal process contribute to forming a state identity as one that adheres to international law or not. And to give a different example, I'll give different examples. So law-abiding states typically internalize international law by incorporating into their domestic structures through executive actions, legislations, and judicial decisions. And this is so for the state immunity doctrine through, for instance, in Canada, the State Immunity Act or the decisions of the national courts on state immunity. But even for quote-unquote rogue states that do not adhere to international law, their breaches of international law and the reaction of other states to these breaches will ultimately compel them to comply with international law as an integral component of their rational self-interest. At the same time, and I argue this in the paper, the transnational legal process theory could be refined by adopting a bit of a more measured optimism concerning the postulate that transnational interactions in themselves invariably lead to better results for justice over time. So the theory emerged in the 1990s during the Cold War, at the end of the Cold War, in a unipolar world where the United States stood as the sole superpower against the backdrop of burgeoning liberal values, democratization, spread of globalization. But this period, as you may know, was short-lived. And as developing states increasingly asserted their presence on the world stage and populist movements in Western states have contested the international legal system, these tensions have created new challenges and also new opportunities for the effective internalization of transnational legal rules. And I suggest that in certain instances they enable states to operate outside or in manipulation of institutional processes. So in short, and to conclude part two, my argument on the state immunity doctrine is that the transnational legal process theory could greater emphasize the necessity of considering not only the rights and interests in state immunity disputes of private parties and foreign states, but also the rights and interests, sometimes not so explicitly stated, of the forum states where the proceedings are brought. And I'll give an example, moving on to my part three, about a contemporary dispute that I believe illustrates the strategies that transform state immunity rules and state immunity disputes. So in 2022, state creditors, award creditors of India brought proceedings in the Quebec court to try to enforce the arbitral awards against India. They sought to have prejudgment measures of constraints, which means interim measures against to freeze the assets of India pending the judgment on the merits. This is precluded by the State Immunity Act. We could stop the analysis there, but that's not what happened. What happened is that the creditor used a commonly employed strategy to go around these rules, which is targeting not the asset of the state, India in this case, but the assets that are of that state that are in the hands of a third party. This is why it sought to get a third party debt order. So the International Air Transport Association owed money to India. In the sense, instead of targeting India, it targeted the International Air Transport Association, and in this way successfully managed to get a freezing order against the assets of India. This is a strategy of the creditor of the state. What did India do? It stopped using this International Air Transport Association air collection fee. Basically, this association, which is based in Montreal, collects fees for airlines and state entities around the world, and it stopped using its services, which prompted the organization to pressure the Quebec government to pass a new law to protect the assets of the organization, of the association, from freezes. And the government did that. So I hope that I'm happy to discuss more about the case or about the theory, but I hope that this shows that if we use, and this is my argument, private international and public international law approaches or theories, and we stopped at looking at the rules, we see only part of the picture, and we need to adopt a socio-legal approach to the question to try to reform the rule by accounting for the reality of the practice today, which involves certain rules but also certain strategies. And I believe that the transnational legal process theory, having this pluralism and having this policy orientation approach, is better equipped to do that. Thank you very much.